Hey guys, welcome back. So we were learning about the definitions of a company, right? So till now we've learned 3 definitions. Now we'll come to the statutory definition. Now what do you mean by a statutory definition? A definition given in the statute. So section 2 subsection 20. See, I told you all the provisions in Companies Act are divided into sections, right? Now the first section will always talk about the title of the act, when was it enacted, what are the objects, as well as what are the applicability provisions. Section 2 of any act, be it Companies Act, Contract Act, Income Tax Act, section 2 always will deal with definitions, okay? Depending on how many terms are used, these terms are divided into subsections. So section 2 subsection 20 defines what is a company. Now, all these definitions are according to the chronological order from A to Z. Okay. So, company is defined under section 2, subsection 20 of Companies Act 2013, which says company means a company incorporated under this act, that is Companies Act 2013, or under previous company law. So, 1956 was one of the previous acts prior to Companies Act 2013. So, as I said in the previous session, all those companies which are incorporated after Companies Act 2013's enactment, as well as those companies which were enacted prior to 2013, which was governed under the previous company law, all those companies will be governed under Companies Act 2013. Okay, so that is what is the statutory definition says. So that is why we did not take the statutory definition, because this will not give you the meaning of company. It will only talk about which companies will come under the purview of Companies Act 2013. Okay. So moving forward, we understanding what is the nature of a company and the features of company. So in certain definitions, what we have already learned, you have known that certain features of company, that is, company is an artificial person, it's a separate entity, it has perpetual succession, right? So we'll be discussing about features of company in detail. So we have 5 features, we have more features, but in your CS syllabus, these 5 features are stipulated. So separate legal entity, then what is perpetual succession, then limited liability, then artificial person, and the last one is common seal. Almost everything you have covered in the definition part, but we'll understand in detail. Okay. To begin with, separate legal entity. So entity is nothing but establishment. Okay. Legal is in the sense which is in the eyes of law only, and separate. Separate from what? Separate from owners, that is the persons who have formed it, as well as the management, the persons who are managing the company. See, one of the important feature in a company is there is separation of ownership and separation of management. See, when we compare it with other forms of organization, a sole proprietor. Sole proprietor, so there is only one single person who contributes to the capital of its business, plus he takes part in the management. That is, the end decision maker is a sole proprietor himself. Whereas in case of partnership, who are the owners? The partners, right? Whoever are contributing capital to the partnership firm, they are the partners, they are the owners of the firm. Similarly, who are managing it? The partners themselves, right? So in partnership, all the partners can take part in the business, or any one partner can take decisions on behalf of the other partners, right? There is mutual agency, but every partner has a right to be consulted. So all these basic things you have already learnt in partnership. But in case of a company, the owners are separate and the management is separate. That means, who are owners? The members. Who are members? People who are contributing to the share capital of the company. Those shareholders are the owners of the company. Now, owners of the company or the members of the company will not get a direct access to the management. By management, what do we mean? The day-to-day decision making. Okay. Let's say we are starting a company when it's going to be operated after certificate of incorporation. Now, what are the basic things you need to do? The basic functions of management, which is planning, which is organizing, which is staffing, that is human resource management, then directing, then controlling. These are the basic functions of management, right? So, planning what to do, when to do, how to do, what exactly to be done is a planning function, which the owners or the members will not have a direct access. Similarly, organizing. What are the men and materials required? How much resources do we need to start our operations? Where to accumulate these resources? Can members take direct decisions on that? No. On staffing, how many human resources required, what is the experience, what are the qualifications required for what job, all that end-to-end human resource management part. Then directing, that is nothing but giving instructions to the employees to get the work done, and controlling, checking the actual results with the standards, right? So these are the basic functions of management. Now, in a company, the owners cannot directly take part in the management. So what does it mean? Owners will be appointing board of directors. So board of directors is a collective term comprised of each individuals who are called as directors. So only directors can take part in the management. So all the business decisions, setting objectives of the company, framing policies for the company, framing policies for each department, deciding an organizational structure, setting policies for marketing, sales, HR, legal, all these things cannot be done by a owner or a shareholder directly, but they have to appoint a director, and collectively they are called as board of directors. Okay, so separation of ownership and management. The reason I'm telling you about the board and management is company is different, the owners are different, and directors are different. Okay, for example, let's say I invest money in a company. I become a member. Let's say I want to incorporate. I came up with a business idea. When I come up with a business idea, do all the preliminary steps, I am called as a promoter. Okay. Later on, when I subscribe my name to the memorandum, I become a member. Now, I can also become a director in a company. There is no prohibition that a member cannot become a director, but a director should be validly appointed by the company. Now, at the time of incorporation, directors are named in the Articles of Association as the first directors. So, if my name is in the Articles of Association, I become a director also. Okay. Now, what does separate legal entity means? So, there is difference between member, directors and the company. All these three persons are separate. You cannot hold member responsible for any actions of the company, nor you can hold company responsible for a member's action. Similarly, directors are not liable for the actions of company, and company is not liable for the actions of the directors. So, all these three persons have different capacities. They are treated separate persons in the eyes of law. Okay. So, there is no mutual agency whatsoever with respect to these three persons. So, it is a person which is different from the subscribers to the memorandum of association. So, there are different ways a person can become member. First mode is by subscribing to the memorandum. Second mode is by when the company after incorporation it allots shares to its members, they become member, right? Then any beneficial owner also becomes a member of the company. So, one of the mode is by subscribing to the shares in the memorandum. When a company is registered, it is clothed with a legal personality. So, we have already spoken about what are the rights of a company, right? It can have a name, it can have its own assets, it can enter into contracts, it has a right to sue and to be sued. When will it apply? It will apply only when it is registered. So, registration of a company is compulsory, unlike other forms of organization. Sole proprietorship registration is optional, again depending on what law is applicable, what is the nature of activity. Okay. Partnership under 1932 is optional, whether the partners want to register or don't want to register their firm, it's up to them. But a company, when people are coming together for forming a company, it has to be compulsorily registered under Companies Act 2013. Okay. Then its existence is distinct and separate from those of its members. So, owners are not responsible. What does it mean? Let's say you are a sole proprietor. You have taken some credit from a outsider. Okay. So, it's your responsibility to repay him. You utilize the business assets to repay the debts of the business. If at all the assets of the business is not sufficient, then can you tell to the creditor that my business has no assets? Will the creditor keep quiet? No. He says use your personal assets and give my money back, right? That means a sole proprietor's liability is unlimited. If at all the business assets are not sufficient, he will have to sell his personal assets as well. The same goes with Indian partnership under 1932. The partners are personally and severally liable for the actions or the debts of the firm. If at all the assets of the firm is not sufficient, each partner should contribute according to the proportion in the capital to the debts of the firm. Okay, but in case of a company, if at all it's a limited company, then the owner's liability will be limited. It cannot be unlimited. So the member will not be responsible for any debts of the company. Okay. Member does not even have an insurable interest in the property of the company. Now, I told you company can have assets, right? Company would need a plant and machinery if it is providing any manufacturing services, right? Or it would need some land and building or any assets for that matter, whatever you have seen in the balance sheet, whatever you have seen in your accounts, right? Land and building, plant and machineries, office properties, your laptop, computers, and all the assets of the company. Who has an interest in that? Can you say member has an interest in those property? If I am a member, can I say this plant and machinery belongs only to me? Can I say this land or building belongs only to me? Can I say the stocks of the company belongs to me because I have given money to the company and company has purchased assets from that company? The answer is no. Members don't have any interest in the property. The property acquired by company's money belongs only to a company. Okay. So, the leading case on this point, Makora and Northern Assurance Limited, will help you to understand what exactly does it mean that the members don't have an insurable interest. So, I hope you have understood till now. Separate legal entity. A company is separate in the eyes of law. It is an artificial person. Just like you and I who have different identifications, I am not responsible for your actions, you are not responsible for my actions. Likewise, company is not responsible for members' actions and members are not liable for the debts of the company. Same goes with the management, that is directors as well as the company. Okay, so let's see what we have in this case law. So M, in short, was a holder of nearly all except one shares of a timber company. So there was a timber company. Okay. Now, one person was holding substantial shares in the company, the majority shareholder. See, earlier I told you in the previous Companies Act, private companies or public companies could be formed. Only now we have this concept of OPC. So, for a private company, there should be at least 2 members, without which a company cannot be started. So, company is an association of person, right? So, M and one more person were the shareholders of the company. M was the majority shareholder. Okay, he had almost all the shares except one. He was also the major creditor. See, a person can become a member of the company. A person can become the director of the company as well as a creditor of the company. If at all the same person subscribes to the debenture of the company or has given loan to the company, he becomes a creditor. Okay, the roles, the rights, liabilities will be different and under different capacities. Now, M insured the company's timber in his own name. So, what does it mean? See, this case is about the assurance. Okay, what exactly is this concept? Now, let's say you have some property, okay, be it a vehicle or gold, you can get it insured, right? If at all there is any theft, if there is any damage caused to your property by certain events which are already mentioned, for example, let's say you have a manufacturing unit and there are certain stocks which you have kept in the manufacturing place. Now, there could be an accident due to fire or anything. So, you have a fire insurance. Now, what is the responsibility of the insurance company? If at all the goods are damaged due to a fire, which is by accident, which may happen or may not happen. See, insurance contract is a contingent contract, which may happen, may not happen. If at all that event happens, then the liability will arise. What is the liability of insurance company? To make good to the losses, right? So, whatever is a sum assured, that will be given to the insured. Now, what did M do here? M had insured the company's timber. Now, company's timber is an asset. It is a property. Okay. So, that was insured in his own name. That is not in company's name, but in a member's name. Member, M is a substantial shareholder. He is a creditor as well. Okay. Instead of getting this timber, which is a property of company, insured in company's name, he had insured in his own name, thinking because it's my company. Okay, I have formed it. I have substantial shares of the company. Okay, so based on this logic, he had insured the company's property in his own name. Now, timber was lost in a fire or it was damaged in a fire. Now, as I said, whenever there is a contingent event, on happening of that event, then the liability of the insurance company will arise. So, if you are the insured, you have to immediately inform the insurance company saying this event has happened, and immediately the insurance persons will come, check the site, see what are the remains, what happened to the property, is there any property that can be recovered. So, all that investigation will be done. So, as soon as possible, you have to intimate the insurance company. Even in this case, M also insured the insurance company saying, my goods, that is timber, was damaged in a fire. So, M claimed insurance compensation. So, as I said, sum assured will be given to the insured as guaranteed. But what happened here was, insurance company did not respond to the application made by M, because insurance company said, you have insured this goods, that is the property of company, in your name, not in the company's name. So, therefore, we are not liable to give you compensation. Okay. Held, the insurance company was not liable to him, as no shareholder has any right to any item of property owned by the company, for he has no legal or equitable interest in them. As I gave you that example, I started a company. I have substantial powers of the company as a shareholder. Okay. Now, whatever assets are purchased, it is purchased from the capital contributed by members only, right? That is why we have this concept of capital. Without money, company cannot start. Company cannot be operated, right? All the assets acquired by the contribution of members, just because it is purchased from members' money, no single member will have an equitable interest in that property. No member can claim that this property belongs to me. Okay, so that is what is the understanding of separate legal entity. Company's property is different, member is different. Member cannot claim the property of the company. So that is the meaning of this separate legal entity. I hope you have understood. Moving forward, perpetual succession. So I told you perpetual succession is nothing but continuous existence. So what does continuous existence means? That is, the company's operations will not be wound up if there is any change in ownership, if there is any change in membership. See, in sole proprietorship, I have already given you an example in the previous session. If the sole proprietor dies, or in his old age, or on losing his capacity to enter into contract, what happens to the business? Put yourselves in that business person's perspective. You have invested so much of your money, your effort, your time, your hope, confidence in that business. But there is no guarantee in law that on your death or in your old age, the company will continue or the business will continue, right? Your legal representatives may continue or may not continue. That is, a sole proprietor's legal representatives or children may continue that business, may not continue. There is no guarantee, right? Similarly, in partnership, if there are two partners, one of the partner dies or retires or becomes insolvent, the partnership automatically has to be dissolved, because with one partner, a partnership cannot continue, right? But in case of a company, any change in membership, that means a member can die, a member can become insolvent, a member can transfer his share. Any changes in membership will not affect the functioning of company. Okay, whether it is a one-person company or a private company or a public company, there is a guarantee that a company will continue its business. So that is the meaning of perpetual succession. So members may die or change, that is when there is transfer. Let's say my father had some shares of a company, he transferred it to me. Okay, now I become the member. Just because my father sold his entire shares, the company's functions will not come to an end. But the companies go on till it's wound up. How is company created? By law, that is by following the incorporation process. Similarly, a company can be put to an end only by following the winding up process mentioned in Companies Act. Okay. So this is the first understanding. The shares of the company may change hands infinitely but does not affect the existence of company. Let's take an example of a listed company, Infosys or Reliance or any of the listed companies. Okay. So n number of times the shares are transferred, they are sold, they are bought, right? The number of members keep changing on a day-to-day basis, right? So whenever there is any transfer of shares or any change in membership, it will not affect the functioning of the company, because companies managed by directors, companies owned by members. Okay. Next, since a company is artificial person created by law, alone can bring to an end to its life. As I said, only by following the winding up process, a company can come into existence. It's not affected by the death or insolvency of its members. In case, let's say there are two members in a company and both the members die. Okay. In that case, what happens? There is no transfer. Transfer is voluntary. If at all I want to transfer my shares, I should be alive. I should sign a transfer deed and then the transfer happens. But I am not alive. What happens then? Then transmission will apply. So transmission is a process which will be applicable due to operation of law, which is due to death or insolvency. If a person becomes insolvent, that you all know a insolvent cannot enter into a contract, right? So in case of a death of a member, it will be automatically transmitted to the legal representatives. Similarly, in case of insolvency, the shares of the insolvent member will be transmitted to the official assignee. Okay. So no change in members whatsoever will affect the continuity of company. So this is what is perpetual succession. So this is one of the unique feature applicable for all types of companies, be it OPC or not. Okay. So these are the two features that we'll be discussing in this session. In the next session, we'll be discussing the remaining features. Thank you.